The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, excuse me. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Thank you. Good afternoon, everyone. Next case is State versus Johnson. I would note that Justice Berger is recused in this case. We'll now hear from the appellant.
Good afternoon, Chief Justice Newby and your honors. May it please the court. My name is Kim Hoppin and I represent Mr. Bryan Johnson in this matter. Before I begin, I would like to request that I be able to reserve 5 minutes for rebuttal. In many ways, this is a very typical search and seizure case where we're looking under the general principles of the Fourth Amendment at the interests of the state, primarily in this case being officer safety versus the interests of Mr. Johnson and his personal liberty. In other ways, though, considering the totality of the circumstances of this particular case, it is very of the moment. So this was, it started out as a routine traffic stop, and we have a couple of issues in this case. The ultimate issue is whether Officer Whitley lacked reasonable suspicion to search Mr. Johnson and his vehicle, whether he lacked reasonable suspicion to believe that Mr. Johnson was armed and presently dangerous, such that the trial court erred when it denied the motion to suppress the evidence located in that search. Under sort of the general principles of the Fourth Amendment, we look at whether the facts found by the trial court are supported by competent evidence, and then whether those facts support the trial court's conclusion that there was or wasn't reasonable suspicion. And then we have an additional issue in this case to consider, where the Court of Appeals majority based their finding of reasonable suspicion on facts that had not been explicitly found by the trial court, but the Court of Appeals majority inferred these facts based on the evidence in the hearing. And I would argue that that was erroneous. So routine traffic stops, and I will say also that Mr. Johnson does not contest the validity of this stop. He was stopped. He was a 30-year-old Black man driving at 12:45 in the evening down what was reported as a fairly major thoroughfare in Charlotte. He was stopped because the tag on the vehicle that he was driving did not match the tag to which it was registered. Officer Whitley was driving his police vehicle with his partner, and his partner ran the tag and discovered this discrepancy. So Mr. Johnson was stopped for no other reason. They did not observe any other criminal activity. He wasn't seen going slowly down the boulevard. He wasn't seen looking oddly at officers. He wasn't weaving. There was no other potential criminal activity. He was stopped for this tag. And of note, what Officer Whitley noted and then articulated as a basis for his reasonable suspicion is that as Officer Whitley and his partner also approached, they both approached, one on the driver's side, one on the passenger side, that Mr. Johnson held his hands up, as many defendants are asked to do. He held his hands up, and immediately upon approach, the officer asked him what was going on, and Mr. Johnson said, "I just don't want any trouble. I just want to let you know I'm no trouble." They have a polite exchange about the situation with the tag. Officer Whitley explains that that's why he has stopped him. Mr. Johnson tells him the situation, which is that he had just purchased the vehicle and had not yet been able to switch the tags, or he was, I've had this happen myself, where I think what happened was that he purchased the vehicle, they sent off the registration paperwork, but he was still, he still had the tag for the car that he previously owned. He was able to give the officer that information, such that the officer seemed to accept it. However, he then, after retrieving documents from Mr. Johnson, leaves Mr. Johnson sitting in the driver's seat of the car, goes back to check his information, which I presume includes his date of birth, his name. They're looking for arrest warrants, his prior criminal history. But what I find important here in both the trial court's findings and the Court of Appeal majority findings is that at this point, what Officer Whitley has told the trial court is his reason for having reasonable suspicion is that Mr. Johnson held his hands up as the officers approached. The officer describes it as blading, and the trial court makes no finding about this, but the blading is that he's turning, and the officer describes it as that he's turning in such a way as to conceal something. I think it's important to note that the facts in this case demonstrate that there was another officer on the other side of the car shining his flashlight in, and also the trial court, when making its findings, was able to observe this entire situation on the officer's body camera, which was introduced into evidence at the hearing and was submitted to the Court of Appeals, and I presume that means it's also within your record. And I think offers at least another version of the evidence to compare with Officer Whitley's testimony at the hearing. The entire interaction is very, very quick, but I think it's, and the other thing that the officer noted was that Mr. Johnson was nervous. And I would point out to this court that in many cases, and as far back as 1998, this court has held that nervousness is not a significant feature unless it can be shown to be some sort of extreme nervousness beyond the normal, because even back in 1998, this court acknowledged that it is quite common for people to be nervous when interacting with officers. And if we're looking at this situation in the totality of circumstances, I think it's important to also take into account the norms that we're facing today. It's interesting, I drafted my initial brief about a month after one of the recent killings that has been in the news, and I know that that's not a part of the record, but if we're looking at the totality of the circumstances, just as the majority noted and the dissent also noted that, for instance, the time of this stop is an indisputable fact to be taken into account in this situation, so are the races of the parties, both of whom can be observed clearly in the body cam video and also in court in front of the trial court. So in this case, the trial court found reasonable suspicion based on the officer's noting of this gesture of raising his hands. The officer stated that can sometimes mean that the person has a weapon. Of course, that also means that it sometimes means the person doesn't have a weapon, and there was no finding in any event about whether the officer has found it more probable than not that the person has a weapon if he holds his hands up. He mentioned that he had made this, or he had seen this gesture 10 to 20 times in his arrests or his stops, but he didn't clarify, nor did the trial court find whether this made it more or less likely, just that it was some indication that the person sometimes possibly has a weapon. The trial court, the only other explicit finding made by the trial court was that based on Mr. Johnson's prior criminal history, that those two facts together, the prior criminal history and this hand gesture that he made as the officers approached, that Officer Whitley was had reasonable suspicion to believe that Mr. Johnson was armed and presently dangerous. Regarding his prior criminal record, Mr. Johnson had a number of charges, and Officer Whitley acknowledged at the hearing that he was not aware whether what he was looking at were charges or convictions. He was also not aware of the dates involved, yet he could see that there were prior criminal convictions for, or I'm sorry, not convictions, charges for offenses involving weapons, things like robbery with a dangerous weapon. So without a doubt, serious charges. However, as it turns out, the most recent charge he was looking at was from 2009, some 8 years or more before this event. And only 2 of those 5 charges turned out to be convictions, as was shown when the state later presented a prior record level worksheet during the plea hearing that happened after this suppression hearing. I would argue that based on these 2 things, which the trial court found, that they do not support a finding of reasonable suspicion to believe that Mr. Johnson was presently armed and dangerous. I think, as the dissent argued, that our case law establishes that the defendant is bound by the findings of the trial court when reviewing a motion to suppress. And if the defendant does not challenge those findings, they can't be argued on appeal. And so here we have a situation where the state argues that it should not be bound by the findings, but can support those findings with additional evidence that arose at the hearing, but was not found specifically by the trial court.
Counsel, let me ask you about some clarification on that. When you say
Sure.
that the state is bound by only those express findings of fact, that therefore it is limited to those findings alone and cannot access the uncontroverted facts, though they may be in the record, that were not expressly found by the trial court?
So in situations, I think what our case law says is that when there are no express findings of fact, the court can certainly infer findings necessary to that necessarily follow the finding of the trial court. For instance, if the issue is whether a statement was voluntary or not voluntary, if the trial court allows the statement in because it wasn't given involuntarily, then you can assume the finding that the statement was voluntary. The problem here is that although the defendant didn't offer his own testimony, what was offered in contradiction somewhat to Officer Whitley's testimony was this body cam video. And what I contend is that the trial court was able to hear the testimony and view this body cam video. And for instance, whether or not Mr. Johnson turned his body to reach into the console, that's not in controversy. He moved his body. The issue is what interpretation you can give to that, or what inference you can draw from his turning his body. Did he do it with the intent to conceal? Was there something unusual about that movement? And my argument is that that the trial court had the opportunity to find that, because that's certainly what Officer Whitley was alleging. And the trial court, after viewing all the evidence, including the body cam video, did not find that as a fact.
How would the Bartlett case apply to your position, where we said in that 2015 case, and it appears in the Court of Appeals opinion, quote, when there is no conflict in the evidence, the trial court's findings can be inferred from its decision, unquote. And although therefore, well, close the quote. As a result, since there is nothing to contradict the findings that you have placed at issue, that as a result, the record can be accessed to determine those, as the Court of Appeals did.
Well, I would say this. I think that there are two different questions here. One, so in Bartlett, there was absolutely a material conflict, and I believe it was that there were two, if I'm not mistaken, there were two contradicting expert opinions in that case. In this case, what you have is perhaps an action by the officer, by the defendant, and then the interpretation of the officer of what that action means. And so I think that is, I think there is contradictory evidence. You have in this situation, the officer perhaps said in the light of the courtroom that these things created a reasonable suspicion in his mind that he believed Mr. Johnson was armed and dangerous. However, he walks away from the vehicle, leaving a number of other officers milling about, certainly within firing range. And it just is objectively unreasonable that if he believed he was armed and dangerous, that he would have walked away and left him sitting there. And so I think you do have contradicting evidence. You have a conflict in the evidence about whether this blading was done with the intention to conceal, or whether this nervousness, whether or, I should back up. Whether or not I think the court decides that it can access record evidence to find things that the trial court did not find, although I would argue that there is conflicting evidence about those things. I think even so, the nervousness and the potential blading doesn't add to the calculation of, or doesn't create reasonable suspicion. So I would say in the cases where the court has allowed a reaching into the record evidence to find findings of fact, those are cases where there were no explicit findings of fact made. And here, in this situation, there were explicit findings of fact made and then others not made. And how would you ever be able to determine which things the trial court heard and rejected, and which things the trial court heard and just didn't mention?
And in this case, also where there are the multiple body cam video footage that the trial court saw, is it possible that, to the extent, so the trial judge is looking at that evidence and also listening to the testimony of the officer, particularly on the question of blading and whether the defendant, whether his heart was pumping out of his chest, whether he was nervous, that the trial court could have been looking at the video. In other words, there could be some conflict, but is it possible there was conflict in this case between the officer's testimony and the video evidence that the trial court also viewed?
That's absolutely what I would contend. The trial court not only made explicit findings one time, the trial court made the findings 3 different times. Initially, orally, the trial court stated that it was finding reasonable suspicion based on the officer's discovery of the prior criminal history. That the most recent charge was in 2009. When the trial court made its oral findings at the conclusion of the hearing after the suppression motion and after the plea hearing, the trial court went back and made more explicit oral findings. Again, made very explicit findings all along and left out any finding of blading and nervousness, even though the officer explicitly said that was one of his bases for finding reasonable suspicion. And to me, I think it's very probable that the court observed the demeanors of the parties, and particularly the demeanors of the parties as exhibited in the body cam video during the event in question. I find it quite telling, but it's in your record, and I encourage you to view it as well. So yes, I would say that there's certainly conflict in the evidence in this case. I would also just point out that this court, in its review of the constitutionality of this type of search, reviews de novo whether the evidence, and I would argue the evidence found explicitly by the trial court or found implied by the trial court, this court reviews de novo whether any of that evidence supports a finding that, or supports the conclusion that Officer Whitley had reasonable suspicion to search because he believed that Mr. Johnson was armed and presently dangerous. So I would stop here and save the remainder of my time for rebuttal unless there are any other questions. Looking at all my notes I have. I would just say also, I guess I'll add this, is that in State v. Salinas, which is another Supreme Court case, where this court found problems or did not find explicit findings made by the trial court, this court remanded for additional findings. And that's certainly an option here as well, that where it is not clear that the trial court just didn't think to enunciate that it considered the blading or the nervousness, where it's possible that the trial court rejected that testimony, that this court could remand for further findings of fact. Are there any other questions for me? All right, I'll stop. Thank you.
Thank you, counsel. We'll hear from the appellee.
Good afternoon, Your Honors. May it please the court, my name is Kristen Euchre. I'm an Assistant Attorney General with the Department of Justice, and I represent the state in this matter. A reviewing court must consider the totality of the circumstances. It's error to engage in a divide and conquer approach And the majority of the Court of Appeals did not err in considering the totality of the circumstances when it reviewed the trial court's denial of defendant's motion to suppress. Your Honors, I think that the defendant said in his argument that an additional issue here is the Court of Appeals majorities inferring findings of fact. That actually is the only issue properly before this court. The dissent and the majority did not agree even on what facts it was to consider. The dissent said that the blading and nervousness were facts that just aren't even in this analysis at all. And the majority said all 6 of these factors did not amount to an error for the trial court to have determined that that was reasonable suspicion. And then the dissent said only these 4 things were not reasonable suspicion. So we don't even have properly before this court the determination of the totality of the circumstances. And putting that aside, the propriety of inferring the findings of fact here is clear from this court's extensive case law. It starts with State v. Muncie, which is a case from quite a while ago, 1996, where the trial court entered a written order, which, granted, the opinion does not tell us exactly what the written order says, but it's hard to imagine that a written order could have been entered without a single specific finding of fact, no matter what it would have been on, even if it were just a hearing was conducted on whatever date. But despite that written order having been entered, this court still went on to infer a finding of fact from the trial court's statement. This court determined that the statement, which this is what the trial court said, well, there's no evidence before me that after the brother left that the defendant said, without further questions, I'll talk. And this court inferred from that the trial court was saying there's no conflict in the evidence on this, and that then it could infer the finding that the defendant did not reinitiate the dialogue there. Then Bartlett comes along, where it's made even more clear, as long as there's no material conflict in the evidence, no findings need be made, no specific findings. The findings will be inferred from the uncontroverted evidence. And then this court continued that line of cases in Nicholson, where this court inferred essentially all of the findings of fact in that case, because the trial court orally denied the motion to suppress, didn't make specific findings or conclusions, and instructed the state to prepare a written order, but apparently a written order never was entered. The mere fact that the trial court can believe all, some, or none of a particular witness does not, of the witness's testimony, does not create a conflict in the evidence. The dissent seemed to think that that was possible, that the fact that the trial court could credit some of what Officer Whitley testified about and not credit some of the other issues that he testified about meant that now there's a conflict in the evidence, and that simply is not supported by this court's case law. And Your Honor, just to address the issue about the video here, first, as a threshold matter, it is not clear that the video was reviewed by the trial court other than the video that was filmed from Officer Whitley. If you look at transcript page 226, that's where the video had been played at that point, and the defense attorney and Officer Whitley are discussing it, and it says at the very top of the page, the question is, but the video is your dimension because it's your body cam, right? And then the officer answers correct. That's one perspective, yes. So this is Officer Whitley's video. It's the only evidence that we have that was reviewed by the trial court. Granted, it appears that the other videos might have been on the same disc, which was admitted into evidence, which is, it's entirely possible. I'm not sure exactly what was on the disc that was submitted into evidence. However, it appears that the only video that was in fact reviewed by the trial court was that of Officer Whitley's, showing his vantage point. And even if the other if the trial court had reviewed the other vantage points, that's really not. The question for the court is, was it objective for this officer to believe, sorry, I might have said that. Was it reasonable for this officer to believe, based on what he observed, that the defendant was armed and dangerous? And you can't take into account what some other officers saw in determining the reasonableness of what Officer Whitley had viewed. If we had any evidence that Officer Whitley was aware of what another officer had seen, then we could take that into account. But the only evidence that we have is what Officer Whitley says he observed, and that is what the trial court was basing its ruling on. And moreover, the video, when you do view it, it does not conflict with Officer Whitley's testimony. Because it's body cam footage, it does not show, it's not the same as a person purposefully filming something where they're following the action. It's affixed to the officer. He said it was on his collar, and that it doesn't see everything that he can see. And you can see when you're watching it that at many points you can't even see the defendant's face. You can't see above his shoulders. You can't see what his hands are doing in a lot of the different parts of the video. It's also very dark out, so it's difficult to tell if it was something that the officer could see, but the video was not able to record. It truly does not conflict with Officer Whitley's testimony. Because there is no material conflict, there is no reason that the trial court was required to make specific findings here. There was nothing for it to resolve, and those findings can be inferred from the uncontradicted testimony, and the Court of Appeals majority did not err in so doing. I just want to highlight one thing about Bartlett. Bartlett had two different witnesses. The state put on an expert witness and the defendant put on an expert witness. And this court said in its opinion that neither of them said that disagreed with what happened on the SFSTs. They disagreed with the meaning of that performance, which is what defendant is essentially saying here. He's saying that, yes, I did this thing, but I did not, the turning of his body, but I was not trying to be evasive. However, there is simply no evidence to support that. There's nothing in the record saying there was a different interpretation of that action. And without there being contradictory evidence, there is no need for the trial court to make a specific finding resolving a conflict that does not even exist. The correct standard here, Your Honors, is reasonable suspicion. But the question is, is it more probable than not that the defendant possessed a weapon? The question sorry, it's not even a preponderance of the evidence standard. The question is, the standard is considerably less than proof of wrongdoing by a preponderance. That's what the United States Supreme Court has said in Sokolow and Wardlow. This is a very minimal standard. Granted, it is an intrusion of Fourth Amendment importance, but the standard is a very low bar, and it was met here by Officer Whitley's observations. Case law also fully recognizes and expects that innocent behavior will frequently provide the basis for a showing of reasonable suspicion. Even evidence that is by no means conclusive of wrongdoing can still be sufficient to warrant consideration. All of the facts have to be viewed in a totality and viewed from the eyes of an officer with Officer Whitley's experience and his training, including that he's received additional training in identifying characteristics of armed subjects. And those, his deductions are to be considered by the trial court, even if those inferences and deductions might elude somebody who does not have the officer's same training. Your Honor, I think there's one other point I did want to say just before I pivot totally off of the findings issue. So the trial court did not decline to find these that the blading and that the defendant was very nervous. The trial court said that it had the opportunity to observe the manner and appearance and demeanor of the witnesses and make determinations as to credibility, all of which have been done. And then he went off for several pages worth of transcript, making specific findings. True, he did not recite anything about, he did not say the defendant appeared nervous or that he bladed his body, but the trial court's failure to recite every single piece of evidence does not mean that he did not credit that testimony. In fact, the trial court later said, including but not limited to, said that the circumstances, totality of the circumstances, including but not limited to, and then listed the hand gesture and his prior record. That phrase right there is inviting the appellate court to infer further findings from the uncontroverted testimony. He's just pointing out these two. He's not saying, I don't find the other ones. And he at no point indicates that he finds the officer to be anything less than completely credible. I think that interpreting the trial court's silence on these issues as evidence that that the trial court did not credit Officer Whitley's testimony on those points is still inferring a finding of fact. That's inferring a finding that those things did not happen, or that the officer is not credible. And the evidence simply is not in conflict on those matters. And the trial court did not indicate that it found the officer to not be credible, and it did not indicate that it found those things did not happen. It was merely silent. And to say that because the trial court has made some findings that the other ones necessarily, it's answered all the other questions in the negative, would have a chilling effect on trial courts issuing findings of fact. Which this court has repeatedly said, issuing findings of fact is clearly the better practice, specific findings of fact. The reasonable suspicion analysis here has to focus on balancing the need for the search against the level of invasion from the search. And this court and the United States Supreme Court case law is replete with mentions of the importance of safety considerations. And on top of that, not only the importance of safety considerations, but the fact that being on the roadside is a unique environment that lowers the hurdle, if you will. Adams v. Williams says an officer making a reasonable investigatory stop should not be denied the opportunity to protect himself from attack by a hostile subject. There's an inordinate risk confronting an officer when he approaches a person seated in an automobile. That's Pym Pennsylvania v. Mims. And it's unreasonable to deny a police officer the right to neutralize the threat of physical harm when he possesses an articulable suspicion that an individual is armed and dangerous. Reviewing courts should not unduly hamper the police's ability to make swift on-the-spot decisions or engage in unrealistic second guessing. That's from Sokolow. All of the uncontradicted factual circumstances as recited by the majority opinion in this case support the trial court's conclusion that there was reasonable suspicion in this case. And police officers are not legal technicians. An officer on the roadside must rely on his training, experience, and common sense to come to swift conclusions about a rapidly changing and potentially dangerous situation. So long as the officer is entitled to make a forcible stop and has reason to believe that the suspect is armed and dangerous, he may conduct a weapon search limited in scope to this protective purpose. That's exactly what happened here, Your Honors. That's what the Court of Appeals majority held. And the state simply asked this court to affirm the majority. Thank you.
Thank you, counsel. Rebuttal.
Ms. Hoppin, you're muted.
Oh, sorry. I would like to, first, I would just like to remind this court that the standard of review on motions to suppress is to determine whether the findings of fact are supported by competent evidence. And if they are, then they are binding, and that the conclusions of law are reviewed de novo, and they must be legally correct and supported by the findings of fact. I would say regarding the video, in the reply brief, Your Honors, I did note that there were a number of files included on the disk that was sent to the court, and I identified which one of those files belonged to Officer Whitley. I don't believe the record reflects whether the other videos were viewed. The court had access to them, just as you all will have access to them. It's not entirely clear from the record, but I would say that it is clear that at least the video, the portion of the video identified, it's Officer Whitley's video is identified as the initials for possession with intent to sell and deliver. So it's PWISD. That's how it's enumerated in that exhibit. In Muncie, referred to by the state, the court actually, what the opinion says is that the court entered a written order in which it did not make a specific finding that defendant did not initiate the dialogue with the officers, which was the finding in question, and the finding essential to the conclusion that the court made. I would like to also add that in Bartlett and in Nicholson, as the state did point out, there were no specific findings made. In Bartlett, one of the things the court notes is when the Superior Court conducts a pretrial hearing on a motion to suppress pursuant to 15A 977, only the judge who presides at the hearing may make findings of fact concerning the evidence presented. Concerning what Officer Whitley stated about the items of evidence that he contends created reasonable suspicion, Officer Whitley suggested that the blading was done with an intent to conceal. That's part of why he felt like it created reasonable suspicion. So I think you can take into account the fact that there was another officer on the passenger side door shining his flashlight into the car. That makes it less likely that in the few moments that Mr. Johnson was leaning into his console to retrieve the documents that Officer Whitley asked him to retrieve, that he was intending to conceal anything. But the other thing about the video, while it is true that you can't see everything because the perspective is from a camera that seems to be sitting on Officer Whitley's lapel, you can hear their entire interaction. And there's no indication in the interaction and conversation that they're having that Officer Whitley has any concerns whatsoever that Mr. Johnson might be dangerous. Regarding Officer Whitley's additional training, that's literally all he said about his additional training, that he had been to a class to identify armed subjects. The trial court did not make that finding, even though the trial court could have. And I would argue that the statement including but not limited to does not necessarily mean that the trial court was referring to these facts that I would contend are contested, but rather could have been referenced to the time of the stop, which is a part of the indisputable facts of the record, or that this was believed to be a high crime area by Officer Whitley, although there were no additional facts made about what made this potentially a high crime area. I will note for this court that this court has said in State v. Jackson, which was a 2015 case, that although the high crime area can be considered as part of the calculus for determining reasonable suspicion, that the court noted that it was mindful of the dangers of making simply walking through one's own neighborhood, if it happens to be a high crime area, somehow indicative of criminal activity. And I'll note for this court that Mr. Johnson was simply driving down a main thoroughfare in Charlotte. Any one of us could be on that road. He pulled into a Burger King when he was signaled to stop. Again, there's nothing about that particular location that would indicate criminal activity. And then I'll just also add that our courts often remand cases for additional findings of fact. Again, if this court feels like these findings need to be made in order to clarify what the court did or did not reject in terms of Officer Whitley's testimony. Our courts and our Fourth Amendment jurisprudence do make concessions for or acknowledge that there is a heightened danger when an officer stops a vehicle on a highway. That's why they allow the officer to remove a person from the vehicle. They allow these Terry frisks if it can be shown that there's some reasonable suspicion that the person is armed and dangerous. But routine traffic stops do not always justify the protective search. There has to be that reasonable suspicion. And I would just say that this court is able to recognize changing norms as it has done in death penalty jurisprudence. And I would encourage this court to acknowledge that we are learning about implicit bias. Thank you. I think the timer ended. I appreciate your time this afternoon.
Madam Clerk, would you recess court, please?
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now in recess. God save the state and this honorable court. Feel better?
Yes. Woo.